Start.
A very good morning to all of you attending this session at SIROHI'S law classes. Today's our topic for discussion is injunctions, remedies under CPC, civil law. As you know, the remedy is provided under section 9 of the CPC, and some remedies of specific nature meeting out the urgency and the emergent situations have been provided under the Specific Relief Act. So almost entire remedies are covered either by section 9 CPC or by Specific Relief Act. Section 9 talks of remedies of a civil nature, dispute of a civil nature. So any dispute which is of civil nature may be tried in a suit before a court, civil court. And for what people come to the court? To have some remedy. If somebody is infringing your rights, people would like to have faith in courts and seek and help. So this help of the court is by way of instituting a suit under CPC, under section 9 or the Specific Relief Act. So remedies can be classified under two heads. Remedies which are preventive in nature, where the right is likely to be infringed and there is a threat perception, and where the right is already infringed. So to correct that infringed right in a right mode, enforcing the right, civil right. So mandatory injunctions, mandating the defendant's other party to do a particular act, and the prohibitory injunction to prohibit a person, defendant, from doing a particular act. So decree of prohibitory injunction or for mandatory injunction is sought in a civil suit, and if there are some emergent situations, plaintiff may move an application under order 39 for temporary relief, because in getting the decree of the court, which will be the outcome of the after trial of the suit, will take long time. So by that time there is more and more likelihood of your right being continuously breached. So a temporary injunction application would lie only in a suit proceeding. It is not so that no suit is instituted for permanent injunction, perpetual injunction, and a temporary injunction is sought. It is not possible. Only in a suit for perpetual injunction, either in form of the prohibitory or the mandatory, the temporary injunction application would lie. So it is usually made on the first date of the hearing of the suit. So at that point of time the defendant is not present in the court, so plaintiff prays the court to grant this injunction in absence of the defendant without hearing the defendant. So it is called, in technical language, in legal language, the ex parte injunction. An injunction granted in absence of the defendant is called the ex parte injunctions. Suppose court chooses to issue notices to the defendant on this temporary injunction applications, then you may further make a request to issue ad interim injunction. And now, so long as interim injunction application is pending, request for an ad interim injunction during the till this interim injunction application is disposed of, plaintiff be granted a relief in temporary nature for a certain period. So that is called ad interim injunction. So there may be temporary injunction, before temporary injunction there may be ex parte injunction, and before ex parte there may be ad interim injunction. Basically the nature of the ad interim injunction or the interim injunction is almost same, because both the orders are passed before the defendant appears. In the absence of the defendant, orders are passed. So far as a person may be aggrieved by issuing notice, because plaintiff wants relief and court is not granting issuing notices. So issue notice, admit and issue notice is an interlocutory order. So no revision would lie under section 115 CPC, and when the defendant appears, the temporary injunction application is decided on merits. This order is appealable order under order 43, rule 1 and 2. So no revision would lie against grant or refusal of interim injunction. Only remedy would be the appeal. What should be the criteria when the court grants the injunction? The basic principles are the prima facie case. The prima facie case would mean what is your capacity to hold, your capacity to have an interest in the subject matter. Suppose it is a suit for injunction, whether you are in possession, number one, in what capacity you are in possession, whether you are owner, tenant, or whatever the position may be. So you have to prima facie show the legal capacity to hold your possession. If you are legally entitled to hold the legal possession, only a prima facie case can be made out. The second would be the balance of convenience. Balance of convenience, if injunction is granted, who will face the hardship? So injunction should not be passed when it may create hardships to the parties, whether the plaintiff or the defendant. If injunction is granted, it is the plaintiff in whose favor convenience, balance of convenience lies. So second aspect is the balance of convenience. Third aspect is what is that third? Irreparable loss. Very important aspect, because if injunction is not granted, the very purpose of filing the suit may frustrate. So there would remain no occasion, no purpose of instituting the suit or keeping the pending the suit, and then complicating the situation, amending the plaint and amending the relief clause. If it was a suit for injunction, prohibitory injunction, and wall was demolished, then plaintiff has to amend the plaint and now would seek a suit for the mandatory injunction for removal of the wall, if we take the example. There is one more important aspect, that there is a concept of anti-status quo. If after institution of the suit some developments have been made by the defendant, or so to restore back the position as on the date of filing the plaint is called anti-status quo. What was the position at the time of instituting the suit has to be maintained by the parties. Another aspect is irreparable loss, we already discussed, and one more aspect is that it is not a legal right. The remedies under Specific Relief Act are equitable remedies based on the equity. So maxim is, one who seeks equity must do equity. So a plaintiff must come before the court with clean hands, no concealment of facts. A bona fide behavior should be there in order to get an injunction. One more aspect is that what will happen if your temporary injunctions are disobeyed. court grants the injunction but defendant is disobeying it. So order 39 rule 2A gives an answer to this question and provides for attachment of the property of the defendant and the simple imprisonment. Simple imprisonment is a civil imprisonment to be distinguished from an imprisonment under criminal law. It is a civil imprisonment not exceeding 3 months. On the same way, what will be the remedy when perpetual injunction is disobeyed or violated by the defendant, who has now become judgment debtor? So the order 21 is a complete code regarding the execution of decree as well as covering the cases of disobedience of the perpetual decree. What is that section? Order 21, rule 32. It deals about the disobedience of the perpetual injunction. So in nutshell, it was all about the temporary injunctions. Thank you very much.